Hello, and thanks for joining us for Law in the Library. I'm your host, Robert Reeders. The Alachua County Library District and Three Rivers Legal Services have partnered for over 10 years on the Law in the Library series. Three Rivers Legal Services is an LSC that's provided free civil legal services since 1978. They have offices in Gainesville, Fernandina Beach, Jacksonville, and Lake City, and provide assistance on domestic violence and family law, housing and landlord-tenant issues, foreclosure defense, money and debt, veterans issues, record sealing and expungement, elder law, hurricane and disaster assistance, and public benefits. Their telephone number is 352-372-0519, and their website is www.trls.org. Today's presentation is on Injunctions for Protection, presented by Brittani Melvin, the Director of Legal Services for Peaceful Paths Domestic Abuse Network. Ms. Melvin earned her law degree from the Florida Coastal School of Law, and her areas of focus include workplace discrimination, children's safety and placement, and injunction for protection. And now, Ms. Melvin, I'd like to turn it over to you.
Hi, I'm Brittani Melvin. I am the Director of Legal Services at Peaceful Paths in Gainesville, Florida, and I will be giving a brief overview of injunctions for protection today. And I just wanted to go ahead and get started. So very quickly, we'll talk about what injunctions for protection are and what they are. So a lot of people commonly call our office and ask about restraining orders and what the difference is between an injunction and a restraining order. In Florida, they're called injunctions for protection. There's not much difference between them. That's just a language use. And there is a difference between an injunction for protection and a criminal no contact order, however. So criminal no contact orders are typically part and parcel with injunctions for protection on the criminal side. So that's something that the criminal court will issue to keep the defendant, in that case, the respondent in the injunction case on the civil side, away from the petitioner or the victim in the criminal case. The criminal no contact orders last for the life of the criminal case. So however that criminal case closes, the criminal no contact order will go away once that case has concluded. That's the major difference between the criminal no contact order and the injunctions. An injunction can last much longer than a criminal case. It can be indefinitely until further order of the court, more commonly known, or it can be for a period of time or a time certain. And what that just means is that the court will write a date and time in the order, and the order will expire of its own volition at that date. And where you can file an injunction for protection is at the courthouse. You can also file them online at the self-help with the self-help center in Alachua County. In the rural counties, Bradford and Union, you'd actually have to go and file them in the courthouse. But you can file an injunction for protection for domestic violence, dating violence, stalking, sexual violence, and repeat violence. And I'll go through all of those with you today. And we'll start with domestic violence injunction. So domestic violence, as we understand it legally, is the assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in the physical injury or death of one family or household member by another family or household member. So domestic violence a domestic violence injunction will focus on the acts of violence that took place, but it also focuses on the type of relationship that existed between the petitioner and the respondent. So to file a domestic violence injunction, it's required that the relationship be either a family member or a household member, so somebody that's related by blood or marriage. Household members, somebody that you're living with as if you were a family, and regardless of whether you're living together or not, it could be people who have a child or children in common. And in filing these injunctions, what typically happens is you would fill out the petition. So you would include that information, the nature of your relationship with the person that you're wanting the injunction against, And then you have to list out the allegations portion or the facts of what happened between you and the person that you're looking to get an injunction against. A lot of times what I see in these domestic violence injunctions is people attach like police reports, or they'll give like police report numbers, and the court is confined by what you've put within the four corners of that petition. So they can't go in and look up that police report. They can't get ascertain any information from something that you've attached. You have to actually write out what happened between you and the person that you're seeking the injunction against. On the flip side of that, or in addition to that, you can also file injunctions, including your minor children. If your minor children were present during the incident, if your minor children were the victims in the incident, those things you can potentially file an injunction on behalf of them as well. That's more important when you're talking about dating violence injunctions. So they have a different requirement than domestic violence injunctions, obviously. And what a dating violence injunction requires is that there be a dating relationship that existed within the last 6 months between the petitioner and the respondent, with the expectation of affection or sexual involvement that was ongoing and continuous. So you have to have been in a dating relationship, essentially defined by affection or sexual involvement. There are some additional caveats with dating violence petitions that are different from domestic violence petitions. They also require that the petitioner be either in imminent danger of more violence happening, or the victim, imminent danger of becoming the victim of domestic violence again, or that they're in imminent danger of domestic violence happening to them in the future if the court declines to grant this injunction. That's the intention of filing a dating violence injunction. Different from the domestic violence injunction, it does not have the requirement that you live together. It also doesn't have the requirement that you don't have to have minor children in common. So it's the relationship that's focused here, but the relationship is different. This one is one that parents can file OBO their teenage children. You have to be 18 years or older to file an injunction. And so parents often file these on behalf of their teenage children, unfortunately, in teen dating violence situations. When you do that, if you're filing against another teenager, what typically happens is you file OBO your child against the parent of the other child, OBO that child, on behalf of, is what OBO stands for. And that's how dating violence petitions work. They're very similar in how you would craft the petition. Like I said, you cannot attach a police report. You can't attach a school, like a school detention slip or something like that if the incident occurred at school. The parent either has to have direct knowledge of what happened, they have to have witness reports and those things as well when filing these petitions, and presenting them in front of the court. And then we have stalking injunctions, which are completely different. And so stalking legally is defined as willfully, maliciously, and repeatedly following or harassing or cyberstalking another person. So when filing stalking injunctions, the behavior has to be directed at a specific person, or it has to be pertaining to a specific person. And the contact or the communication must not serve a legitimate purpose. So what that means is, if your child's father is contacting you because they want to reach out to their child, they like to have contact with their child, not in every situation will that constitute stalking. That could be foreseen as a legitimate purpose, essentially. However, in terms of the contact being directed at a specific person or pertaining to a specific person, that is a little bit of a change in the law, and what it encompasses is cyberstalking more than anything, because what we see more often now are stalkers reaching out to other people, or communicating about a specific person consistently, nonstop, on social media websites, Facebook, Twitter, Instagram, and the like. And so that kind of encompasses that portion of it. And again, in the same process, you will fill out the petition, you would go through all of the allegations. And in this instance, it's always important to attach whatever communications you have so that the court can see the voluminous records, if there are voluminous records, but also so that it can be proven. You need to bring that with you to court as well, so that the court can see that these are the times of days that the messages are happening, that the messages are there for the court to view. They cannot view them on your cell phone. If you have videos, they can't view those videos from your phone. You have to have the physical copies or a jump drive with videos on them for the court to be able to introduce them into evidence and consider them. So always make sure that you have that information on hand when you're coming to court. The additional thing with stalking injunctions is that typically they require more than one incident, obviously, the repeatedly portion of the definition of stalking. So it has to be more than one time. And you have to keep in mind that it cannot serve a legitimate purpose. That is a part of the stalking injunctions where people often get caught up because sometimes the communication does in fact serve a legitimate purpose. Now we move to the sexual violence injunctions. So sexual violence injunctions require any one incident of sexual battery or lewd or lascivious act, or any forcible felony where a sexual act is committed or attempted. And this also includes sexual acts on children. Children are included in this. And again, with this injunction, parents can also file on behalf of their minor children against a party. In filing these injunctions, you have to have reported the sexual violence to law enforcement. It doesn't require that they move forward with the case. There's not a requirement that there be a conviction. There's not a requirement that the case proceed, but it does have to have been reported to law enforcement, to the state attorney's office for an investigation and for opportunity to move forward. It's not up to the petitioner to ensure that the state moves on the case, but it does have to have been reported. And they have to be cooperating in those criminal proceedings, regardless, again, if the case moves forward or not. Another instance where you can file a sexual violence injunction would be if the respondent had been convicted in criminal court of one of these sexual misconduct crimes and they're about to be released from prison. So either their imprisonment term for the Sexual Violence Act has expired or it's going to expire. Now, the caveat here is that you have to file these injunctions within 90 days of their release. So it's incumbent to be aware of when that time is and make sure that you're proactive in getting this filed. With the sexual violence injunctions, the petitions operate again the same. You have to include the allegations of what happened. You have to name the party, both parties, the respondent and the petitioner. If you're filing on behalf of a minor child, you would include the minor child's information as far as their name. And that's pretty much it on that end of sexual violence injunctions. Now, the repeat violence injunctions is something that our office sees a lot less. We don't typically file these injunctions, mainly because these injunctions move away from intimate partner violence. And our sole focus is not intimate partner violence as a legal team here at Peaceful Paths, but obviously this is a domestic violence shelter. And so the repeat violence injunctions typically tend to not involve the intimate partner relationships at all. And so our office rarely files them. So for repeat violence injunctions, you have to have 2 instances of violence or stalking committed by the respondent on the petitioner. And at least one of these incidents has to have occurred within the last 6 months of filing the petition. Again, like I said, these are filed less frequently than the other petitions. And these situations, repeat violence situations, and times and instances that I've seen them most are in situations where there isn't that familiar relationship. So the parties are roommates or they're friends, they're people that know each other, acquaintances of some sort. And the petition is very similar. Like I said, the petitions are similar in nature, in appearance, and you file the party's information, your information as the petitioner, the respondent's information, where to find them, and then you would include the allegations in the petition as well. Um, for all of the injunction paperwork, the process after you filled out the paperwork is pretty similar. So after you filled out the injunction and you filed it, the court would review that paperwork, and typically you get a response back from the court the same day that the injunction has been filed. These are filed on the emergency basis. That's why you get a response back typically on the same day. And in filing these and the court reviewing them, one of three things can essentially happen. The injunction could be denied outright. The matter could be set for hearing, meaning that within the four corners of the petition, the court needs more information. It doesn't necessarily mean that you don't have enough information to proceed on an injunction. It's just that the court needs additional information, and that's why it's been set for hearing. The final thing that could happen is that the court would issue what's called a temporary injunction, and then that temporary injunction would go before the court as well to be either extended to a final injunction or dismissed for whatever reason. Once you get to court, if you have a court date, that is where you want to make sure that you have all of your evidence. So you want to have your photos, you want to have your videos on a jump drive so that the court can receive them into evidence when you're presenting your case to the court. And essentially what you want to do is explain what happened to the court, very similarly to how you explained it in filing the paperwork. Once you've explained to the court your version of what happened, the respondent also has an opportunity to be heard at these hearings. They have to be personally served with the paperwork that you filed with the court. And once they appear, they also have the right to tell their version of what happened as well. The court will consider all of that information and then make another determination, a final determination. And in that final determination, the injunction can be dismissed or the injunction could be granted. And that's where we'll go back to what I said in the beginning, where the injunction could be time certain, meaning that the court will write a date in the order and it will expire on that day. Or the court could grant an injunction until further order of the court, meaning that the injunction will be valid until such time that either party petitions the court to dissolve or dismiss the injunction. And either party has the right to do that. It requires another hearing, but it can be done. And finally, I did want to provide everybody with Peaceful Paths information. If you have any questions, if you believe that you're in need of assistance, we service all survivors. This is our office number, 352-377-5690. And then our helpline number, if you need immediate assistance, it's a 24-hour line, 352-377-8255. And then our website is also included here, which is www.peacefulpaths, PeacefulPaths.org.
Thank you so much for that great information, Brittany. And I want to thank you all for attending today's presentation. Our next Law in the Library episode will premiere on Wednesday, March 12th at 5:30. The presenter will be Angela Caldwell, and the topic will be Medicaid budget waiver eligibility and enrollment. Previous episodes of Law in the Library are available on the library's website at www.aclib.us/law-library. Okay, thank you very much, and we'll see you next time.